Suppose you have been running a business with a co-partner and you have also made a WhatsApp business contact for that. One day you want to call it quits and you have made this decision with the co-partner that after your exit, they will be the one who will be removing your name from all the business cards, from all the business letterheads, and from the WhatsApp logo of WhatsApp contact details as well. Now suppose they fail to do so, and after your exit they are running the business as usual. Now you do not have any control on whatever they are now doing, however they are running the business, whatever they are now promising to the clients, you have no control over that. But can you still be made liable as a partner even after your exit? You would say yes, because of mutual agency and vicarious liability, that the one partner's act binds the other partners as well. But the answer in this case is no, and this we will understand in Tower Cabinet versus Ingram case. And it will be interesting for you to know that the retiring partner can be made liable by the plaintiff civil suit just because their name was still showing on the company's letterhead and it was not removed. Want to know how? Let's start with the case. So the facts of the case are, there were two partners, S.J. Ingram and A.H. Christmas. They started their partnership in January 1947 and lasted till May 1948. So, and they ended the partnership on mutual agreement. They had this arrangement between them that Christmas would be notifying the customers of the firm, the customers the firm was dealing with at that moment, about his exit. Ingram on his part had already intimated the bank about his exit, and one thing that he did not do, maybe because he did not find it useful or necessary to do so, that he did not publish this change in the constitution about this decision of his in the gazette or in the newspaper to make it public knowledge. And that's where it became the mess that it became. So after Ingram's exit, A.H. Christmas did not honor the arrangement. He went about with the business and he did not do whatever Ingram had asked him to do. And after 9 months of Ingram's exit, this joint company that they had, and yeah, one more thing, they had a household furnishing business. The partnership firm got into a transaction with the client named Tower Cabinet. They had ordered to buy some pieces of furniture from Tower Cabinet. This transaction was made on credit. A.H. Christmas ultimately failed to pay off Tower Cabinet's bills. Tower Cabinet sued the firm and Ingram as well, saying that the letterhead, the order, the purchase order had Ingram's name as well, and that's what makes him the partner. And one more thing, A.H. Christmas actually printed new letterheads after Ingram's exit, but it actually happened that the old stock and the new stock were in use simultaneously. So maybe in this, so quite possibly in this transaction, they did not notice this and made the purchase on the old letterhead. Now, what were the issues in the case? According to English Partnership Act 1890, was Ingram liable as a partner by holding out? Holding out means whether he did represent himself as a partner or knowingly allowed himself to be represented as a partner. First, let's prove that first. Second, as per the plaintiff Tower Cabinet, who was claiming that Ingram was an apparent member of the firm, and this was the impression to the outside world that he was still associated with the firm because he did not publish this in the gazette. He did not make this known to the public. Now, what was the ratio in the case? If we talk about the Indian equivalent of the English Partnership Act, holding out is defined in section 28 in the Indian Partnership Act, and section 32 tells about the retirement of a partner. 28 says that if a partner is holding himself as a partner or knowingly allows himself to be represented as a partner, then he will be taken as a partner and he will be liable for the acts of the firm. Section 32 says that a retiring partner would still be liable for the acts of the firm even after his exit if he fails to provide notice of his exit, because to the outside world he will still be deemed as a partner because they are not at the fault, because it was your duty, either your duty or the surviving partner's duty, to intimate this to the customers. It's not the customer's fault at all because he did not know about this change in the constitution of the firm. But there is an interesting caveat in section 32 which provides protection to this retiring partner in terms of the person dealing with the firm who did not know this partner as a partner with the firm. They just did not know him that this person was associated with the firm as a partner. They did not have any knowledge, and if later on they come to know of it, that doesn't matter actually. So with respect to this person who did not know that this retiring partner was actually a partner in the firm before the firm got dissolved, this partner's inability or this partner's failure to give public notice about his retirement has no effect over his case, because this person did not know him as a partner before also, and after his retirement, if they come to know later on by any means, that holds no value, because you actually never dealt with that person in any capacity before while he was actually a partner. Now let's come to the contentions of the parties. What did the plaintiff say? First, that by letting his name show on the letterhead, Ingram had actually knowingly suffered himself to be a partner. He had knowingly allowed himself to be a partner, either by his own conduct or by his consent. Second, that by failing to give public notice to the world by publishing it in a gazette that they are no longer associated with the firm, Ingram has given the impression that he was still continuing with the firm. He was still a member. He was still an apparent member of the firm. So it was nobody's fault, but only Ingram's fault that he failed to do so, and he will be then held liable. And third, plaintiff relied on a case, Farrar versus Delphin, in which the court had given two distinctions. First, notorious partners, and second, profoundly secret partners, and tried to base the case on that and try to say that the Ingram was a notorious partner. Okay, now let's understand these two distinctions. First of all, the meaning of notorious in law is different than its meaning in English. Notorious in law means widespread, open to public, very obviously it can be inferred. So notorious partners are one who are the partners in the eyes of the business, and profoundly secret are the ones who have never been known to the public. Maybe they were dormant, maybe they were sleeping, nobody knew of them, that they were the partners in the business. Nobody knew about them. So now the plaintiff was trying to bring Ingram into the notorious partners category on three grounds: that his name was on the letterhead, that the partnership was registered in the Business Names Act, third, by his failure to publish in the Gazette to give public notice of his retirement, he becomes the apparent member. The people will see him as still the continuing partner with the firm, and they would not have known by any other way about his exit with the firm. And also that he was careless in ensuring that after his exit, the old business communication was removed. His name was removed from all those documents, from all those letterheads. So that is also a way of holding out. Now let's come to the contentions of Ingram. Ingram said that he had no knowledge that A.H. Christmas would do such a thing, that he would actually make a purchase order on a company letterhead which had Ingram's name on it. Secondly, Ingram did not even authorize for such an act. This was actually a clear breach of the arrangement between them two, because he asked him to notify about this change to all the customers, and he did not do so. And secondly, the point that plaintiff is making, that Ingram knowingly suffered, knowingly allowed himself to be holding out as a partner, that is also not true, because to be holding out as a partner, actual knowledge and consent is important. I did not have knowledge that he was using such a paper, and I did not even consent to that. So that also goes out of the window. And Ingram also says that they never had any transaction with this company. They never had any dealing, any prior relationship with the company. They did not know of the partnership. They did not know Ingram was a partner while he was a partner. So now they are trying to misuse the situation, and they are trying to show that they entered the transaction on the faith of the partnership. And how is that possible? Because they are trying to misuse the document that was created after his exit. Now that's another issue, that was it deliberate or was it a sincere mistake on Christmas's part, that we will come to later. But they are trying to misuse the situation. They are trying to paint the picture altogether opposite. This company is completely a new client which was taken aboard by A.H. Christmas after his exit. What did the court say? The court said, as per section 36 of English Partnership Act, whose Indian equivalent is section 32, which says that be it dormant partner, be it a sleeping partner, be it an active partner, if they fail to provide a public notice about the retirement to the customers, to the persons dealing with the firm, they will be liable to them only. But they are given protection in terms of those people who did not even know them, who did not even know about them as a partner while they were actually a partner. And still, even if they do not publish and fail to give public notice, they are not liable to these people, because they did not know of them to begin with. In the very first place, they did not know of them as a partner. They never dealt with them. So in Ingram's case, since they never dealt with them, they cannot hold him liable. His failure to give public notice does not affect his case with respect to Tower Cabinet. Second, court said, since the plaintiff got to know about this person Ingram through the letterhead, they cannot retroactively try to position him or try to paint him as a partner that they knew of from the beginning, because they did not know of. This later acquisition of knowledge cannot retroactively hold Ingram liable. And third, since Tower Cabinet was calling Ingram the apparent member, he was painting him that he was still an apparent member, he would be seen as a partner still continuing with the firm. This is actually not true with regards to the world. What matters is the actual knowledge of the very person, of the specific person who is dealing with the firm. Did they know about this partner as working as a partner or not? Do not compare this with the public information, the general information. So it was held that Ingram was not liable to Tower Cabinet on account of either of these sections, neither on section 14 of English Partnership Act nor on section 36 of English Partnership Act. So I hope I was able to explain this case well to you. If you have any doubts, if you have any clarifications, maybe you have some viewpoints to share, please write them down in the comments below and I will try to answer them as soon as possible. So now let's see you in the next video with the next case. Until then, happy reading, happy studying, take good care of yourselves. Bye-bye.